I'm going to call the Board of Zoning Appeals hearing to order this morning, and we have case number 6556 that's before us. And Mr. Dixon, could you go ahead and introduce the file for us, please?
An application for an expansion of a non-conforming use to show the correct number of parking spaces needed for a summer day camp at a daycare center. The site is located at 3459 Shiloh Road, Hampstead, Maryland, on Property Zone A, Agricultural District and Election District 8. By IMTD Properties LLC, attention Randy Kelsey. Code of Public Local Laws and Ordinances, sections 158.033, 158.063, and 158.133. A site visit is tentatively scheduled for May 21st, 2025 at 10:45 a.m. In the file of this matter, we have the following documents. A response to Joe Vance's request to various state and local agencies from Laura Matthias, Bureau Chief Development Review. A site plan may need to be processed in accordance with Chapter 155. Contact the Bureau of Development Review at their phone number. There is a response to Joe Vance's request to various state and local agencies from Mary Lane, Bureau Chief, Bureau of Comprehensive Planning. There's an attached memo. There's a May 19, 2025 memo from Carly Falat, Comprehensive Planning Technician. The above BZA case has been reviewed for consistency with the policies and recommendations contained in the Carroll County Master Plan as amended in 2019, the Carroll County Water and Sewer Master Plan, and other functional plans. Planning staff finds that because the zoning code implements the Carroll County Master Plan as amended in 2019 and allows for the limited expansion of non-conforming uses, the application is consistent with the master plan. There's a May 19th, 2025 letter from Daphne Daly, the Secretary to the Planning Commission. After having reviewed the information contained in the attached analysis, the facts as presented in the application, the relevant portions of the applicable comprehensive and other functional plans, and in accordance with the provisions set forth in the land use article, this conditional use request, if granted, is consistent with the policies, timing of the implementation of the plan, timing of development, timing of rezoning, development patterns, land uses, and densities or intensities. There is a May 16, 2025 email from Gail to a Jonathan Bowman. And it's 3 pages. There is a response to Joe Vance's request to various state and local agencies from Thomas Harris, permits and inspections. There are no comments from a permits and inspection standpoint at this time. Signed, Thomas Harris. There is a comment from Anastasia Yemelyanova, zoning administrator. Hearing notice was posted for this case April 28th, 2025. There is a response from Tammy Ledley, Town Manager, Town of Hampstead. This property is outside the Hampstead town limits. The town has no opinion on this matter. There is a response to Joe Vance's request to various state and local agencies from Lisa Staley, Carroll County Environmental Health Department. Proposed use may not be acceptable unless it is demonstrated that there is an adequate water supply and adequate area for the installation of an initial and 2 replacement septic systems for the proposed use and any existing uses of this property. There is a response from Janet O'Meara, Bureau Chief Resource Management. Comments? None. Hearing notice was posted April 23rd, 2025 by zoning inspector Michael R. There is a response from J.P. Smith Jr., Program Manager, Ag Land Preservation Program. This property is not in ag preservation. I have no comments at this time. Then there's an application. There's a drawing by BPR, First Amended Site Grading and Landscape Plan. Some aerial photographs. I would ask that the file be entered into evidence.
Do we have a motion to enter the file into evidence?
So moved.
It's been moved and seconded to move the file into evidence. All those in favor, aye.
Aye. Aye.
All those opposed, no. Okay, I'm assuming you're Mr. Kelsey. You're an audience of one. Go ahead and come to the table, sir. And before you sit down, I'm going to ask you to take the oath, so could you please raise your right hand? Do you swear or affirm under the penalties of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can have a seat.
Thank you.
And I'm assuming you signed in on the clipboard?
Yes, I did.
Okay, very good. The only other housekeeping detail is make sure that you leave by the same door that you came in, so they're not, the outside door, so that they're not looking for you at the end of the day.
Understood. I have that same problem at work sometimes.
There you go.
Badge in, badge out, so we don't leave anyone behind.
Okay, so you're here, your application is for an expansion of a non-conforming use to show the correct number of parking spaces. Could you go ahead and explain what the non-conforming use is and the number of parking spaces?
Certainly. So my wife and I own child care centers in several places in Carroll County, one in Baltimore County as well.
Oh, wait, before you get started, state for the record your name, address, and occupation, and spell for the record your last name.
Okay.
I'm sorry.
No, my fault. I've never done this before.
That's fine.
Randy Kelsey. I live at 1239 Babe, B-A-B-E Drive, Hampstead, Maryland. Last name is K-E-L-S-E-Y. I work as an electrical engineer. So we're here for this nonconformance for the child care center that we purchased in 2017. So when we purchased the center in 2017, there was 30 parking spaces there. I was unaware that the site plan had never been updated. That was nothing that was ever discussed during the transition from the previous owners to us. And the reason this has come to the surface is my wife wanted to run an outdoor camp at the preschool. The lot is like 3 acres, so we have plenty of space in the backside of the lot to host a summer camp under a different Maryland agency. So the child care centers are run under the Office of Child Care. We have in the past run our summer camps under that agency, but we are limited to the number of children we can have, and the way the ratios work, it's a little more confined than switching over to the summer camp program under the Maryland Health Department. There's slightly less regulations, and the ratios for students to teachers is in the favor of the center, so we can have more kids per adults. So we figured we would file the application to get the summer camp put under the health department. And as this process rolled through, they needed a use and occupancy permit for the summer camp specifically. And as Anna looked through the site plans, I think she looked at the original site plans when the original part of the building was put in 96 or 97. It showed 10 or 12 parking spaces, but that was a smaller building. And then I think in '06, which is the dates
How many parking spaces did you say?
I think there was 10 or 12 at the most at
thanks.
that point. I didn't look that close at that set of drawings because in the process of doing this, once we got started, they found a more recent drawing, which was from 2006, which showed the expansion of the daycare center. So a big expansion went on. It went from like, I don't know, say 3,000 square feet to what it is now at 7,500 square feet of space. And when they did that, they added parking spaces, and that number went to, I believe, 16. And sometime between then and when we purchased the building, the owners dug out an area next to one of the driveway entrances and added an additional 10 or 12 spaces. So the updated redlined drawing, I shouldn't say updated, the redline drawings that I presented as part of my package shows where the additional spaces are, and the overhead drawing shows that the parking spaces, are there. From a standpoint, a quick calculation of square footage, we were probably about 2,000 square feet that was disturbed to add these spaces, which my understanding is much less than or a bit less than the 5,000 square feet requirement to trigger a complete site plan redraw. So at this point, we have the 30 parking spaces that not zoning, I guess the zoning, the office where we're going to get the use and occupancy permit comes from. I just need to show that we have the 30 spaces, and in order to do that, I've got to come here and get this drawing redlined and permission to move forward.
Okay, board members, any questions? I've got one real quick. Existing, how many spaces do you have?
Existing right now, there's 30 spaces.
You have 30 spaces?
We have 30 spaces, yes. We've had 30 spaces since we bought the place in 2017. The drawing just does not show those.
Okay. Board members?
Yes, I have a question. So you've got 30 spaces, but a number of, we noticed when we did the site visit, a number of vehicles are parked on a gravel area, so it's not defined as individual spaces. Are you planning to blacktop that area and mark it out?
If I have the financial ability to, yes, I will. But do they need to be marked? I guess that's a question that, I don't know. So we've been parking the 30 vehicles there for the last, what is it now? 7 years, 8 years now since we bought the place.
It's just dotting an I and crossing a T. I don't see it necessary that if you can accommodate the 30 cars, you've met the objective.
Yes.
Thank you.
Thank you.
I have a quick question. How many employees total are on site at any given time?
The maximum at any given time will be, this is a tough question because we have full-time people, we have part-time people, we have high school kids that come in, they get off the bus after school, probably no more than 20, 18 to 20 22, somewhere
Would
in
be
that
parking at
ballpark.
any given time?
Yeah, so the parking lot is normally fairly full. There's 2 or 3 spaces that are open pretty much at any time of the day. And then if you see the way the design works, the parents come in off of Shiloh Road and stay to the right, come to the front of the building. They'll either park, right in front of the building and come get their child. They're there for, 2 to 5 minutes, and then they circle back around and go out.
And then how many, how many kids, I guess, same question, kind of,
Yeah,
on site?
the center is licensed for 100 children,
Okay.
and we probably run around 80 to 85 kids maximum per day at any one given time. Obviously, it starts out with, 5 or 10 at 6:30 in the morning when we open, and then it works to its maximum to about noon, and then the numbers start going back down, progressively from there till, 6 o'clock when we close.
Okay.
So it ebbs and flows. It's not set up where 100 kids show up at the exact same time like a school.
And the summer camp, is that going to add more employees, or are you going to utilize the same employees so that extra space?
Right, we will probably add 2 or 3 employees total, but we transition some of the employees from one of their positions during the year because the way the business is set up, we run full daycare service from 6 months to elementary age, or through 12 years. So we have a before and after care program. So we have teachers who will be there for the before and after care, and then normally they leave and come back, or we'll have one do it in the morning and then someone else does it in the afternoon. And then we also run preschool classes for parents who want to bring their children in for like 3 hours in the morning or 3 hours in the afternoon. So those teachers are also certified to do the school age. So we'll transition them because they only run from September to now. So in the summer, they either will be at home and not working, seasonal working, or they'll transition and work for the summer camp. So our employee count will only adjust by, a couple, yeah.
And the children that you currently have, you assume that they're going to be in the summer camp as well, or?
Some of them, yes, but we add a lot more children. So part of the whole check for the parking spaces was because, and with the health department for the water system and the sewer system, was the number of children will probably go from about 80 to 120 or so.
Okay, thank you.
Yep.
No question, just a comment. I was kind of surprised that the town of Hampstead, you're inside the city limits.
No, we are not.
You're not, then I'll withdraw my comment.
Yeah, when I heard that, I was like,
I said,
we're not in
Hampstead, no
Hampstead.
comment. I'm thinking, well, if you're in the city limits, why wouldn't they have some semblance of a comment? But,
Yes.
you're.
Yes, I'm almost positive we're outside the city limits. I checked at one point, because I had to have a new well drilled, about connecting to the water, which I knew there's connectivity in the development just adjacent, but that they only connected like half of that development. And they were gonna like say, well, yeah, we could do it for about 300,000. I'm like, I'll have the well drilled.
Well, you either pay city taxes or you don't, so.
Yeah.
Yeah.
Okay, any other questions? Mr. Kelsey, anything else to add?
No, that's all we're looking to do. I think
Okay.
we're-
At this point, presentation of testimony and evidence is now closed, and if you would like to make any summation comments, you can make those.
I appreciate your time, and hopefully I've understood everything that was been presented to me, and I have done everything correctly, and there's no issues with this. Thank you.
Okay, the hearing and record of this case is now closed, and in accordance with the Open Meetings Act of Maryland, the board will now consider the case. Board members,
I'll start.
Mr. Caldwell.
It appears that, over the time that you've owned this property, you've done everything that the county states required you to do to run this daycare center. The issue of the parking, you've already got the 30 spaces that's required by code. So I don't see any problem with it at all.
Ms. Ford Mount.
I agree. This is just a formality that now on record, you have 30 spaces there that you need for the summer camp, and it seems like that's all been taken care of, so I have no problems with moving forward with it.
I'm in concurrence.
No, nothing further from me, no problem.
I mean, we're looking at a timeline here since the building was built. The spaces have gone up knowingly. Had the correct number of parking spaces there. It was just a formality, and that's all we're here looking at. There was no opposition in the file to what you're doing, and I don't see any reason that we can't approve this. Okay. Board members, anyone, any other comments?
You want a motion?
Motion, please.
In case number 6556, before the Board of Zoning Appeals, that the board approve the application for an expansion of the non-conforming use to show the correct number of parking spaces needed for a summer camp at the daycare center.
Do I have a second?
A second.
Okay, any discussion on the motion? Seeing none, all those in favor, aye.
Aye.
All opposed, no. The motion carries. Our oral decision will become final upon a written decision which will be issued within 30 days unless otherwise extended by this board. The board's decision may be appealed by filing a petition for judicial review with the clerk of the circuit court for Carroll County in accordance with the provisions of Chapter 200, Title 7 of the Maryland Rules of Procedure. The appeal must be filed within 30 days of the date of the board's written decision. Thank you very much, and this hearing is adjourned. BZA hearing to order, and this morning our second item on our agenda is case number 6558. Mr. Dixon, could you go ahead and introduce the file for us, please?
All right, case 6558, an application for a modification of a nonconforming use of 2 lots and variances for the minimum lot width and size of each lot. The site is located at 118 City View Avenue, Westminster, Maryland, on property zone R10,000 Residence District in Election District 7 by Samuel Weber, Code of Public Local Laws and Ordinances, Section 158.033, 155.075.03, and 158.133. A site visit is tentatively scheduled for May 21st, 2025 at 10:15 a.m. And to file this matter, we have the following documents. A response to Joe Vance's request to various state and local agencies from Andrea Gerhard, Community Planning and Development, City of Westminster. We would like to reiterate the comments provided by Mark Depot on June 5th, 2023, as part of this packet. A new water and sewer application is required, and a good cause waiver is needed. Allocation is first come, first served. There is no guarantee allocation will be immediately available. Andrea Gerhart. There is a response to Joe Vance's request to various state and local agencies from Laura Matthias, Bureau Chief, Development Review. The Bureau of Development Review has no comments at this, on this request. There is a May 19, 2025 memo from Carly Falat, Comprehensive Planning Technician. The above referenced BZA case has been reviewed for consistency with the policies and recommendations contained in the Carroll County Master Plan as amended in 2019, the Carroll County Water and Sewer Master Plan, and other functional plans. Planning staff finds that because the zoning code implements the Carroll County Master Plan as amended in 2019 and allows for the limited expansion of non-conforming uses, the application is consistent with the master plan. There's a May 19, 2025 letter from Daphne Daly, Secretary to the Planning Commission. After having reviewed the information contained in the attached analysis, the facts as presented in the application, the relevant portions of applicable comprehensive and other functional plans, and in accordance with the land use article, this conditional use request, if granted, is consistent with the policies, timing of the implementation of the plan, timing of development, timing of rezoning, and development patterns. They left off densities or intensities. Okay. There is a response to Joe Vance's request from Thomas Harris, Permits and Inspections. There are no comments from permits and inspections from a permits and inspection standpoint. There is a comment from Anastasia Yemelyanova, Zoning Administrator. Let's see, she highlighted which in the opinion of the BZA is of the same or more appropriate use or classification unless the use is specifically prohibited in the district. The use need not meet the bulk requirements except for minimum for area of the underlying zoning district. However, it shall meet all other requirements of the county code, including any requirement of Carroll County Health Department. Also highlighted legal nonconforming use. The second structure existed as a dwelling, was continuously used as a dwelling, and use as a second dwelling was not stopped for more than 2 years. April 28, 2025, the notice of this hearing was posted. There is a response to Joe Vance's request from Lisa Staley, Carroll County Environmental Health Department. Comments? No comment. There is a response from Janet O'Meara, Bureau Chief, Resource Management. Comments? None. There's a comment to Joe Vance's request to various state and local agencies from J.P. Smith Jr., Program Manager, Ag Land Preservation Program. The property is not in ag preservation. I have no comment at this time. Hearing notice was posted April 23rd, 2025 by Zoning Inspector Michael Roth. And then there's the application, modification of a non-conforming use of 2 lots and variances for the minimum lot width of each lot. There's an April 11, 2025 letter from David K. Bowersox to Joe Vance. There's an April 10th, 2025 letter from David K. Bowersox to Joe Vance. All right, there is a memo email from June 5th, 2024, from Tom Harris to Andrea Gerhard. After researching the property, it appears that both dwellings were built before the records that we have access to. It is permits and inspections position that we would consider both dwellings as being approved dwellings. Additionally, the Department of Assessments has 188 City View, lots 20 and 21 as being one parcel with 2 dwelling units, and 118 City View, lots 22 and 23 as one parcel with an outbuilding. There are some emails from Andrea Gerhard to Mark Depot, and from Mark Depot to others. And there is a plat from DRS Associates. I would ask that the file be entered into evidence.
Do we have a motion to enter the file into evidence?
So moved?
Second.
All those in favor, aye.
Aye.
All opposed, no. We will enter the file into evidence. Before we get started this morning, make sure that if you haven't done so already, sign in on the clipboard on the side. Sir, I'm assuming you're not with this group, you're a resident? Okay, so I will go through the process that we're going to use here this morning. Mr. Bowersox, I'm assuming, is the attorney representing the client here this morning. Mr. Bowersox will give opening comments. He will then call witnesses. After the witness gives their testimony, you'll have the opportunity to ask them questions of their testimony. The board will also get the same opportunity. When Mr. Bowersox has completed the presentation of his case and his witnesses, then you'll have the opportunity to go ahead and go to the microphone and state your comments about this case. So I guarantee you'll understand it when the process is over. The first part of this is just questions of the witness's testimony. So with that, I'd ask that if anyone's going to be a witness here today, could you please stand and raise your right hand so that you can take the oath? Sir, you might as well stand and take the oath. If you don't say anything, it won't cost you anything. Okay, do you swear or affirm under the penalties of perjury that the testimony you are about to give is the truth, the whole truth, and nothing but the truth? Yes. Very good. You can have a seat. And please state your name, address, and occupation, and spell for the record your last name before you speak. Mr. Bowersox.
Thank you, Mr. Chairman, members of the board. Initially, an item of housekeeping. I note that you have taken the application into the record as evidence. I would like to make a correction of a typo on a portion of it. It's the narrative statement portion. And I have, in the second paragraph of the narrative portion, I indicated that 2 residences were built on lots 20 and 21 after 1942 and the date that Carroll County began keeping records. It should be after 1942 and before the date Carroll County began keeping records. I believe the Tom Harris email that Mr. Dixon has indicated for the record gives some additional clarity to that, but I didn't want to not take care of that unfortunate typo in the narrative statement. As far as I can tell, the rest of the narrative statement is accurate. Initially, to try to set the stage, this case is all about getting building permits for both of the dwellings now located on lots 20 and 21. The first thing we'd like to establish with the board, and we believe the evidence supports it, is that these are lawful non-conforming uses. You're going to see that the subdivision from which they were created was recorded in 1942. Before 1963, 1965, for over 60 years, these 2 dwellings have been at this site. So they predate not only Carroll County's planning and zoning codes, they predate the city of Westminster's planning and zoning codes, which were adopted, I want to say 72 or 79, sometime in the 70s. So at the time they were established, they're lawfully created. As Mr. Harris alluded to in his email. Unfortunately, after the construction of these dwellings, the county code and city codes came into being. These houses were built, as is not uncommon, they were built across the property lines, of lots 21 and 20, and the State Department of Assessments and Taxation began recognizing them for real property tax purposes as a single lot with 2 residences on them. There was never a deed of consolidation done. They still legally exist as lots 20 and 21 for purposes of the boundaries. So what we would like to do is, with the recognition that they are both non-conforming uses, lawful non-conforming uses, it's once that's established, we'd like to be able to split lots 20 and 21 instead of running laterally off of City View, split them in the middle to create 2 new lots, which will have the principal residences on 2 separate lots. Why are we asking for the recognition of the non-conforming use? What this case boils down to is the need to obtain county zoning approval on an application for water allocation to the city of Westminster so that they can allocate water to one of the residences. The water was turned off at one point in time. Mr. Krinsky's predecessors were an elderly couple. And
Okay. Could you, I hate to interrupt you, could you,
Ask him,
sir, what is your name?
Alex Krinsky.
he's a client, I have to eliminate myself.
Okay. So, Mr. Snyder,
Yeah, and I'm sorry about that for not
His
communicating.
name never appeared on anything, so I never
yeah,
saw
the
it.
name we saw
Oh.
to see is Samuel
I
Weber.
see now, I see.
And he is a client of my company.
Oh, and neither we nor Mr. Staley knew that either, so I
I
apologize.
recognized you, but I was waiting to validate.
Yeah,
because I am
I'm-
old and I screw up every
I was gonna say I'm sorry about that for not.
So-
He inquired about that, and I said, I underlined Samuel Weber, and he said, okay.
Yeah.
So,
Before you depart, I know you'd probably really like to stay. Samuel Weber is actually the title owner of the property. Mr. Krinsky is a partner of his, investment partner, who's been handling all of the administrative matters pertaining to the management of the property.
okay.
Thank you. And so I will abstain.
You recuse.
and I'll recuse myself from the case.
Okay.
Okay.
Thank you. Just take care.
So the point is, we would look.
Sorry, I didn't mean to interrupt you, but
No, that's okay. Hello? I'm sorry. A lot of times I come in here and they say they can't hear me, but, so we have, we'd like to be able to get the water, service back on, but because the counties and cities rules against, service, there can't be more than one principal residence on one lot. That's the dilemma that we're in. This is basically all about tidying up the boundary line so that we can get zoning approval with a license, or excuse me, a recognized nonconforming use. And then to tidy it up, we'd like to get the boundary done, and that's what the variances are for, the boundary reconfigured. And I'll walk you through these things chronologically. Initially, I'd like to call first Mr. Krinsky.
I'm Alex Krinsky, residence 3240 Farm Lane, Manchester, Maryland, 21102. As Mr. Bowersox was saying, I help Samuel Weber. We have some properties together, and I take care of some administration and management for some of his other properties. So I'm here to kind of help with that process today.
All right, were you familiar with when Mr. Weber acquired this particular site?
It was August of 2023.
All right. And since that time, have you been handling predominantly the administrative aspects of the properties, getting them ready for tenanting and managing them?
Yes.
All right. So, are you aware of whom Mr. Weber bought the property from?
I believe it was Mr. Coons, if I have the name correct.
All right. And what were the circumstances of the property? Who had been residing in the residences? Was it Mr. Coons?
So, yes, so it was Mr. Coons, but he had passed away, so it had gone to his daughter, who was the one who ultimately sold the house.
All right. And during the time of her disposition of the property, it was untenanted, is that correct?
I believe so.
And to reduce costs on the family, they elected to have the water service turned off to one of the dwellings?
Yes.
Okay. But it's always remained a residence since that time, correctly?
Correct.
You're correct? So it's never been used as a storefront or any other kind of a use but a residence?
Nope, just a residence.
Okay. And that's how they were marketing it to you? All right. And to the best of your knowledge, this is in the R10,000 zone in the city of, in the Carroll County, is that correct?
Yes.
So the, And single-family residences are permitted uses in the R10,000 zone.
Yes.
So the use itself is not non-conforming in the zone. It's the configuration of the two residences across the two original lot lines. Isn't that correct?
Yes.
Okay. Now, do you believe that by doing this, this is the most beneficial utilization of the property if you're granted the relief that's being requested here today?
Yes, it would be, instead of leaving the house vacant or unusable, we can actually take care of it and it can be utilized.
And the house is in good shape?
Yes.
Or you're not planning any new construction?
No.
All right. So you basically want to take what's there as is and, for lack of a better description, bring them back into viability.
Correct. So it actually already has a connection for sewer and water. It's already established. It's just turned off at the street. It's just a valve on the street.
And even though you're in the county, the properties are being served by city water and sewer service, is that correct?
Correct.
Okay. Therefore, that's where the city comes in with their requirements to be complying with county zoning before they turn the water back on?
Correct.
Do you feel like the relief you're requesting, if it's granted, is going to have a negative impact on neighboring property values or the, peaceful enjoyment of the neighbors in their homes?
No, with no construction and taking a vacant property to something that's usable, I think it'll enhance the value of the
Okay.
neighbors.
Okay. Can you think of any detrimental impact on any of the neighbors that the relief you're requesting would have?
I don't think so,
All
no.
right. What about property values, neighboring property values?
I think it'll improve the values by taking something that's vacant and unused and putting care into it and making it
Okay.
usable.
Okay, and it's in decent enough shape to be re-rented or something along those lines?
Correct.
Okay. Is there anything else you'd like to add?
I think that covers most of it.
Okay. I have no further questions at this time for Mr. Krinsky.
Okay, are there any questions of the testimony you've heard so far? Go to the microphone and state your name, address, occupation, and spell for, you can just go to the standing microphone back there and, that's okay. And,
Mark Babin, I'm the neighbor to the lots that they have.
and spell for the record your last name.
Babbin. And if I'm hearing this correct, they want to divide the property in half so that the house on the back lot and the house on the front lot are going to be separated down the middle. Is that what I'm understanding?
Yes.
And you're wanting to fix up the house in the back?
Yeah.
Well, I knew Mr. Coons when he was alive, and from what I understand, I've never been in the house. My wife was a lifelong friend of the people that lived there, and it's my understanding that that house has been, nobody's lived in it for years and years. It's asbestos throughout, the siding and the interior.
And that's actual testimony that you can give a little bit later, but you have any questions? Or at least put that in the form of a question.
Okay, how are you gonna improve that house without modifying it?
Sure, so we're not gonna do construction as in building something new, but we will do some touch-ups or renovations to make it better. Like a remodel. It's not construction in the sense that we're gonna build or expand, but more of just clean up what's already there.
I have a question. Mr. Babin, can you identify your address, please?
126 City View, Westminster. And you're saying there's a valve on the street for the house in the back?
Yeah, there's actually two separate valves, because I met with the water department, And we actually had it turned on, or it was on, for like a inspection or a test. So they are separated. There's one by the fence and one on the corner. One goes to the front house and one goes to the rear house.
And what about the sewer for that same back house?
That I'm not 100% sure, but I know there's sewer connected to both.
Okay, it was my understanding that the sewer from the back house went to the front house, of course, before all the laws and stuff came in. But, my whole concern here is the property lines that are, you had it surveyed, and my garage is like 6 inches from one of those property lines. Is this gonna change? Are they gonna build another house on that property? Or can they build another house on that property?
So I'm trying to think, if we're facing the property.
You're facing the property, I'm on the left. Yep, by the driveway of the garage.
It shouldn't touch anything because there's setbacks too. So nothing should encroach on your property. There should be a buffer. And I think we talked before, right, to the trees, about cleaning up some of the trees too.
Yes,
I didn't forget for the trees.
yeah, well, that's a whole nother story, but, have you been by the property recently?
I was gonna swing by after this.
Yeah, the grass is this high.
Yeah, I'll get that taken care of.
All right, that's all I have. I just wanted to understand that the sewer and water's already existing.
Oh, yeah.
Any questions?
That is,
Go ahead,
I have a question. The intention for the houses is to be rented, sold? What's the intention?
The intention is for the rear one to be rented. That will get it into like a rentable condition. And we have some other rental properties, so we'll take care of it. We'll do it right. I actually have a MHIC license as well.
But there are 2 homes, correct?
Yes.
So one will be rented and one will be sold?
The front one will be rented as well.
So they'll both be rentals? Thank you.
Mr. Caldwell?
From Mr. Babin's questions, he indicated there may be asbestos in the property, is that correct?
I have to double check, but I believe so, for the siding, for the rear house.
For the siding, okay. So you would have to remediate that?
Correct.
To come to code, right. So if I understand correctly from Mr. Bausox's opening presentation, this all revolves around shutting off water and then deciding they can't put it back on, even though the houses have existed there for 80 years, is that correct?
That's the city's position.
That's the city's position to, that's unbelievable, just amazing.
No comment.
You have to reapply if it's been off for 2 years or more.
Has the water been off for 2 years? Is that the,
I believe so. The prior owner's daughter wanted to save some costs while she was trying to figure out the best way to dispose of the property. And there wasn't anyone living in it at that time, so that's what happened. But the thing to remember is in terms of the use and whether it's vacant or not, they were built as houses lawfully. They've existed as houses lawfully for well over 60 years. The houses themselves are not the nonconformity. The location of the houses is causing some problems, and we'd like to eliminate those problems by reconfiguring the boundary line originally to separate the houses on 2 completely distinct parcels, and hopefully avoid any continuing interjurisdictional confusion into the future. To do that, we need you to recognize them first as lawful nonconforming uses, which county staff seems to acknowledge. And second, if you can grant the variances we need to reconfigure them, it's going to make life much simpler going forward for if Mr. Weber and Mr. Krinsky decide they want to sell one and keep one, it'll allow them to do that, which they cannot do now.
So a question for you, what is the lot size right now, the combined lot size?
The combined lot size is about a quarter of an acre.
So it's 10,000 square feet, right?
Yes.
A little bit more than 10,000 square feet.
Each lot is approximately 4,880, well, more than approximate, 4,888.68 square feet. That won't change when we're done. They'll still be the same size. The boundary will just be, instead of a lengthwise axis, it'll be a horizontal axis through the properties. And I'm about to show you what we're proposing.
Okay.
So Mr. Staley will testify on that.
Yes.
So the question I have then is that just for clarification, is that I should shut up until Mr. Staley speaks.
It's your prerogative.
Okay, I don't have any more questions. Any follow-up, Mr. Bowersox?
No.
Any
no.
clarifications
I
after?
understand he's curious and he's had a concern. I think it's been addressed, but.
Okay,
How do you spell your last name, sir?
For Krinsky, it's Krynski.
okay. Thank you very much for your testimony. Mr. Bowersox, you want to call your next witness?
Yes, I'd like to call Dan Staley.
Dan Staley, 52 Winter Street, Westminster, Maryland, with DRS Associates.
Mr. Staley?
And we'll go ahead and accept him as an expert witness. He's been here many times before, and I knew that's what you were going to request.
Thank you very much. Mr. Staley, I'm showing you a document. It's a reduced size version of what I'm going to have admitted as Exhibit 1.
Thank you, sir.
You're welcome.
Thank you.
Can you tell us what that document is?
Well, it's a record plat of Hollow Rock addition to Westminster, prepared by John J. John in 1942.
And there's a highlighted portion of it. Can you identify what that highlighted portion is?
Yes, they are lots 20 and 21.
As they were created in 1942.
Correct.
All right. Has this plat ever been amended?
There's been portions of it that's been amended, but not these two lots.
Okay. So as far as you know, the legal descriptions of these two lots is as it's shown here on this 1942 plat.
Correct.
All right. I'm going to show you, I'm going to have marked as exhibit number 2.
Thank you, sir.
Could you tell the board what this drawing is?
Well, it's our boundary survey of lots 20 and 21 of Hollow Rock's addition to Westminster. It also shows both houses on the lot. The one that fronts on City View is a split foyer house. It's the newer of the two houses. The one in the back that would front 48th Street is the older of the two houses. It's also, it is a two-story. Last time I saw it, I thought it was in pretty reasonable shape. It was kind of an interesting looking house for for that, for what it is.
Okay. Now, the dark lines, they portray the aggregated lots 20 and 21 as we've seen on Exhibit 1,
Correct.
but with a horizontal boundary. Is that correct?
Okay, well, the boundary runs, on the lots, runs from City View to 48th Street. And then each lot, 20 and 21, each front 30 feet on City View and also 48th Street.
Okay. So what does this portray in Exhibit 2?
Well, what we attempted to do there was to reconfigure the lots and keep the area of each lot the same as they were originally platted on the plat of Hollow Rock Addition. So we're splitting them from City View to 48th Street. There's another dark line that runs through the middle of that lot, and of course, we give bearings and distances of the lot dimensions there. So now the lots, instead of being 30 by 163, they're going to become 60 by 81 and a half.
Okay.
And then, so then each house would be on its own separate lot, and I guess that's it.
So, according to the modern R10,000 standards, they're not they don't meet code in terms of lot width or.
Yeah, lot area, they don't meet the code for lot width, lot area, or setback.
And that's what the setbacks, we don't need a variance from if it's a modification to non-conforming use.
I would agree with you there, yes.
But the others, we are here asking for those variances?
Yes.
Okay. Do you think this circumstance poses an unreasonable hardship on these properties?
I don't.
Well, I mean, the existing circumstances where they're both forced to be located on the same lot moving forward and maybe being able to be served, is that an unreasonable hardship in your opinion?
Well, it certainly makes the, for the owners, it makes it harder for them to, I guess, realize the full value from their property. 'Cause selling, one property with two houses would be, you'd have less of a market than you would if you could sell a single-family home on a lot.
Right. And this could conceivably, if they can't be reconfigured as you're showing on your sketch, that could in fact prevent them from being alienated or sold independently, could it not?
Correct.
Okay. Did you hear Mr. Krinsky talk about his perceptions that there would be no negative impact on neighboring and adjoining properties from granting the relief that we're requesting? Did you hear that?
I did.
Do you agree with it?
I do. I mean, really, all we're doing here is just striking a line on a piece of paper. As far as what it looks like in the ground and how it functions in the ground, I don't see that changing.
All right. And it'll also facilitate getting a building permit if we can do this, can it?
Is it building permit or zoning certificate that we need?
Zoning certificate, I'm sorry.
Yes.
Okay. I'm going to show you what I'm going to have marked as exhibit number 3.
Thank you.
Thank you, sir.
Is this your last exhibit?
Hmm?
Is this your last exhibit? Okay, okay.
Thank you.
Now, this purports to be an email from David Beecraft to Anastasia Yanagino, the zoning administrator that was mentioned before. Have you seen this before?
No, I have not.
Okay. In it, David from Development Review indicates it's possible to reconfigure these lots through a deed and not amending the plat. Would you agree with that?
Well, the plats before we had any control, any planning and zoning in the county, so yes, I would agree with that.
Okay. And again, Exhibit 4. I'm showing you what I'm having marked as Exhibit 4.
Thanks, sir.
Have you seen this document?
No, I have not.
So it purports to be in part initially on the first page, an email from Tom Harris to Andrea Gerhard. And can you tell us who Andrea Gerhard is?
She's a planner with the city of Westminster.
Okay. And Mr. Harris is with permits and inspections here in the county, correct?
Correct.
On the first page, there's a highlighted portion that indicates the permits and inspections position, they'd consider both dwellings as being approved dwellings. Sort of further amplifying on his comment made in response to the zoning administrator's solicitation of comments. Would this be your understanding of their status as legal nonconforming use?
Yes, we actually, from the county records, pulled up a 63 aerial that showed both houses at that time. So of course, that was April 63 is the magic date for Carroll County. So we were curious that both houses were actually on the ground prior to zoning code. So we have a record of that. We provided that to the zoning office, and I'm not sure if they shared that with permits inspection or not, but I would agree with that comment, though.
And if you'll turn to the second page of that handout, there's another highlighted portion, which is the email of Mark Depot. And Mr. Depot is whom, do you know?
He is the Director of Community Planning and Development in the City of Westminster.
Okay. And it indicates that there has to be a water and sewer allocation application submitted and approved by appropriate Carroll County agencies, stating that a second house at the subject property is permitted, in order to get water allocated to 118 and a half City View. Is that the need for having the board recognize the lawful non-conforming use posed by two of these structures on the original lots 20 and 21?
Yes, just for the board's information, we have submitted a water and sewer allocation application to the City of Westminster, and so far they've denied it until this board rules on what we're here for today. Now, I'll tell you of my personal experience with the city. I had a property where I had a water service, and because of work I wanted to do in the building, as the owners of this property, I had the water turned off. When I did that, I gave up my water allocation. So to get it turned back on, you've got to reapply. And now the city's telling us, in order for them to approve the water and sewer allocation, they need to know that these properties are legal based on zoning criteria in the county. So that's kind of why we're here.
Mr. Staley, is there anything else about this situation that you would like to bring to the board's attention?
Well, as Alex said earlier, there is a separate water connection for the house that fronts on 48th Street. And it's my understanding that when the city came in and updated the water meter, they come into he calls for water service, they come in and put a water meter on, and you turn the water off. So then they said, okay, you've got to apply, so, which is what we've done. And then we believe there is a separate sewer connection to the back house. We've not traced it from the house to the street, though, which would be something that would need to be done before any redeeding or, anything else is done to the property boundaries.
Do you have anything else to add, Mr. Staley?
No, I mean, I think it's a reasonable request to reconfigure the lots. I mean, knowing that the two houses have been there for, I don't know, about 80 years, but probably, 60-plus years. And like I said, it's just a matter of changing a line on a paper. The way it operates in the ground is going to be pretty much the same after as it is before. About the only change to the neighborhood might be if they go from rental properties to individual ownership, which I think would be probably a good thing for the neighborhood. I don't think it's you, but I think ownership probably sometimes take better care than the landlords do. But no, I mean, I think it's all reasonable.
I have nothing further.
Mr. Bowersox, would you like those exhibits to be entered into the record?
Yes, please, all of them.
Okay, and we will go ahead and enter all of Mr. Bowersox's exhibits. Was it 4 of them? 5?
4.
4, into the record. Okay. Mr. Babin, do you have any questions of Mr. Staley's testimony? Okay. Board members, go ahead.
He does.
Oh, wait a minute, he does.
Is this gonna affect any other future? Like, I have 2 lots, is the way I was told. One in the front, one in the back. And their property has 4 lots. The older house in the back, the other house on City View, and then the 2 empty lots next to it. So as it stands now, the line is going from City View to 48th Street, is that right?
Correct.
And you want to make it go
We want to
vertical?
Yes, we want to split the lots halfway between City View and 48th Street.
And that won't affect any other properties if they wanted to do the same thing and put a house behind them, they could go vertical too instead of horizontal?
Well, I think you'd be experiencing the same problems to do that as we're here for today, because the lots are substandard or non-conforming. You'd have to come in and get some sort of a variance in order to do that.
So this is not going to set a precedent for anybody
I
else?
don't think so.
Okay, thank you.
Okay, Mr. Caldwell.
Good morning, Mr. Staley. Good to see you again. Question for you. You referenced the fact there was a water shut-off for the rear property. Is that on 48th Street?
No, the water and sewer are both in City View.
Both on City View. Will the address of the rear property become 48th Street?
I don't know that, but I would think that would be reasonable.
Okay. Looking at this Exhibit 2, is it reasonable to say that the adjacent properties are actually non-conforming as well?
Yes.
So these lots were probably designed for townhomes that were connected, is that correct?
That would probably be a good guess, yes.
So, can you tell me what exactly, and looking at this diagram here, this plat, there's a gray shaded area just to the left of where the line, the proposed plot line is going to be? Can you tell me what that is?
Are you referring to the shaded area that would be to the, if you're standing on City View facing the lot? It
Yes.
would be on the left side of the lot, and it runs between it's a walkway. I think it's what you're describing as a walkway. And it
Right.
runs from the front house to a walkway that goes to the back house. And it's because it's, I don't know if it's a brick walkway, but it's different than the other walks that are not hatched.
So who owns lots 22 and 23?
Uh,
It's Pleasant Valley Road.
I will tell you here.
And just the,
This is
Yeah.
a walk.
Hold on.
I was gonna clarify for this, I'm pretty sure these are pavers.
That's owned by Pleasant Valley Road LLC.
Lakestone Papers.
Pleasant Valley Road LLC.
I believe also to clarify for that walkway, that gray shaded area, I believe it's concrete pavers, so they can just be
It
lifted
can
up.
be removed, okay. All right. So, it's amazing, the bureaucracy people have to go through for something so simple, for something that's, anyway, I'm just commenting. I have no further questions, Mr. Staley, thank you.
Ms. Ford Mount?
I have a question. So is it difficult to find out if the sewer is connected to that other home? Why don't we know that?
We just haven't gone that far yet. I mean, we'll have to get like a trace detector people, someone that can mark public utility lines, which we've done in the past. So we'll need to do that because if there's, we got to get, we know the sewer's out in City View, so we've got to come across the front lot to get to the back lot. You want to have an easement for maintenance purposes, that sort of thing. So yes, we will need to do that.
Okay. And to your knowledge, this will be the only lot in this area that will be split like this? Because all of the other ones seem to go back to front, not side to side.
Well, on the, I guess, the south end of City View, if you look in the tax map, there is another, I don't know if I can tell you the lots because my map that I have. There's been some rearrangement on the south end of City View, much similar to this right here. And I think it was the same circumstances where there are existing buildings on the ground. They just want to reconfigure lot lines to put each building on its own lot.
Okay, thank you.
Mr. Rolls?
I guess, just to this, I'm just curious with, I think you just answered one of my questions, but with putting the boundary line between the two, front house and the back, any plans for a fence or anything between that? What'll delineate that? Is it just kind of maybe, or, I know it's not a requirement probably, but.
Potentially, we're gonna look at it, see what makes sense. It's easier once we're on the ground and we can see, because we want to
Right.
make it comfortable and usable.
Right. And then, and there's been no density concerns prior to this, the way everything's been for a very long time. Is there any other current density concerns that you've encountered from what you're proposing to do? I mean, it doesn't seem like it would be, but for going long-term, if other people in the neighborhood, that Julie just mentioned, they start kind of putting a couple more things, they don't have a house on the back, they want to start putting a house on the back, because it starts stuff. I mean, if I owned a house, I'd probably go, wow, I want to do that too. So is that what happens with that in the future? That's something we have to take in consideration, I think.
I think it'll be a little bit easier too, because we do have those two different streets. So instead of front loading it all onto that one street.
48th Street.
Yeah, that way it's kind of broken up, so it's not all in one place.
So, and there's a separate, obviously there's separate entrances onto 48th for the back
Yeah,
lot.
there's two entrances, one on the left and one on the right. So if you're going out of 48th, you can go this way or this way. Or you can go down to the
Right.
City View.
It's pretty tight there, anyway. I mean, the streets are, I was getting my truck in, and once I figured out where it was, I was like, wow, man. But I mean, I don't know if that would be a big deal down the road to think about, but just saying.
Any other questions? Go ahead.
I got one more question. That 48th Street is just an alley.
Right.
It was paved by the people that lived there prior to me moving in. Everybody gave a couple $1,000s and somebody paved the alley. But it's my understanding that that's owned, half of that alley is my property behind my house. The other half is the people above me. So that's kind of like private property. I mean, the city of Westminster doesn't own 48th Street, is that correct?
I'll try to answer that. I'm
So there's
sorry.
no sewer or water up there?
I'll try to answer that. I can't speak to whether there's any sewer and water in the bed of 48th Street. Maryland law, in the real property article, indicates that where you have these paper streets or alleys shown on a plat, the lots, if they're shown abutting on the plat, are described as abutting on the streets. In the absence of a reservation of title by the owner, which I don't believe there is, or the conveyance of the bed of the street to the city, which I don't believe there is, the law presumes that you own to the center of the paper street. So if those circumstances are present, and I would be shocked if they're not, you do own to the, you would be the owner of half of 48th Street in fee simple. But it would be, it's not private property in the strict sense where you can exclude others. It would be, you own the fee simple bed of 48th Street, subject to the rights of those entitled to the use of 48th Street as an alley, which would basically be all your neighbors.
Does that answer your question, Mr. Babin?
Yes, thank you.
Any follow-up questions, Mr. Bowersox, of your witnesses?
No.
Okay. Okay.
Mr. Bowersox, so that essentially makes 48th Street an easement for that community.
Essentially.
It's been
When they
there.
recorded the plat, well, this is kind of a deviation from where we are today, and please understand, I have not researched the title history of 48th Street.
Sure.
But there is a very strong likelihood, according to what the Supreme Court of Maryland has said over the past 15 years or so, that by recording the plat and showing the paper street, that act may have created an easement for the owners of the lots fronting 48th Street to the use of 48th Street,
Okay,
if not in the public at large.
right. Thank you.
Ms. Ford-Mount?
I have a question for Mr. Babin.
Wait a
Who
minute,
made-
he hasn't, we'll wait till he gives his testimony,
Oh, okay.
so. Okay. Mr. Bowersox, you've completed your process?
I have completed my presentation. Thank you.
Mr. Babin, would you like to go ahead and give testimony?
My only concern even being here today is, if you look at your little map, that's my garage on the left if you're standing on City View, number 24. And I don't know if it was permitted or when it was built or whatever, but it's like 6 inches from the property marker. And if they're gonna be building additional lots on, I guess it's 23 and 22, then they're gonna be really close to my property line. And, you know, I've gotta be able to get at that garage.
But
So that's the concern I'm here today. I wasn't sure what they were doing with the meeting here today, so that's why I'm here.
yeah, but
But if
we're only dealing with lots 20 and 21.
Yes,
Okay.
but that's all I gotta say.
Wait a minute, stay right there. Ms. Ford-Mount has a question.
I just have a quick question. 48th Street, who maintains that? Do you know? Like when it snows and,
Well, we do. There's bushes and stuff. You gotta keep it back so you can get your cars. It's a very narrow alley. And everybody takes care of their own all the way up and
so
down.
it's not maintained by the county, it's not
No.
maintained by the city?
No, it's
It's
not
the
plowed.
neighborhood that takes care of
Yeah,
it?
yeah.
Thank you.
Any other questions of Mr. Babin? Thank you, Mr. Babin. Okay. Where's my cheat sheet? Mr. Babin, you're finished with testimony and, okay, I just wanted to double check. Presentation of testimony and evidence is now closed and summations are in order. Mr. Bowersox.
Thank you. As I said at the outset, we're here asking for different types of relief. Primarily, we're looking for the board's recognition of the uses on this site as a lawful, non-conforming use. What that means is you'd be recognizing that when these residences were, built on lots 20 and 21, they were lawfully created. We know that before the county's planning and zoning regulations were adopted, these houses existed. There's no suggestion that there was illegal construction done at some time between 42 and 63. There just wasn't the regulatory climate in any way, shape, or form that we deal with today. So you have Mr. Harris's email that's submitted with the agency comments, in which we've provided you as well, indicating that these are considered permitted dwellings. There's no problem with that. That, we believe, is a tacit recognition or an express recognition of the legality of the non-conforming uses. In addition to that, we would like variances so that we can reconfigure the boundary line without enlarging either of the two original lots. The resulting lots would be as close to the same size as we can make them, but would give us some relief from lot width and from the lot area requirements of the R10,000 zone. These lots are basically substandard as they were originally created. They're not combined. If we look at it as a tax parcel, they still are non-conforming because they're not 10,000 square feet together. So it's really, you're recognizing the basically status quo situation on the ground with a new configuration of the two lots. You've heard Mr. Krinsky and Mr. Staley testify that there is no anticipated negative impacts on the adjoining and neighboring properties. I don't know that it's possible to conceive that there would be from the requests that we're making. You'd have two viable residences on the site. That tends to increase neighboring property values. You have two residences on the site. You're not building anything else, so it complies with county code requirements for modification of a non-conforming use. There's just not anything there that's going to have a greater impact than presently exists. In addition, with regard to density, to address Mr. Old's question, let's say a neighbor should want to do the same thing. Let's say they reconfigure the lot lines and come in and ask for a variance like we have done here today. Similarly, these lots are all exactly or very close to exactly the same size. In that case, the variance would be proposed, and part of the standard in considering the variance would be unreasonable hardship or practical difficulty. And it could be that with a proposed additional construction on it, which we don't have here, you may determine that that's not practical difficulty or unreasonable hardship, or that it might have a negative impact on a neighboring property owner. So while it's an intriguing question and it's a logical supposition to make, that would actually be a different case than what we have before you today. And you'd have the opportunity to evaluate that on the merits of the facts before you at that time. The other thing I would say is, with all of the discussion that's going on, not just here, but around the state and around the nation, about the need for reasonably priced housing, to let this situation languish is counterproductive to resolving that situation. So, the county commissioners are trying to take some steps to address that. This is a residential zone. We're not intruding into the conservation or the ag zone in the county. It's already got water and sewer service. It's within that area that's historically been served by the city. So you don't have any of the other potential negatives to going out and grabbing additional land for more residences outside the residential zone. This is the residential zone. And what we're asking you to do is for you to recognize the legitimacy of those two structures that have been there for 60, 70, 80 years. So with that, I would request that the relief pray be granted.
I have a question too. May I ask him a question?
No, testimony's over. Okay, hearing and record of this case is now closed in accordance with the Open Meetings Act of Maryland. The board will now consider the case. Board members.
First, if you like. Okay. In this case number 6558, it's clear from my point of view, from the testimony given, that this is to right an ongoing problem. These buildings have been there for more decades than I've been around, and it's absurd that this kind of problem exists in this day and age. As far as I'm concerned, this is more than just a non-conforming use. I think it's a certification from this board that they are lawful properties. So, I would suggest that we address that as part of your request, that we recognize them as, well, from my point of view anyway, I don't know if everybody else agrees, but as lawful properties, caught up in this, the problem of changing rules and regulations, which essentially has created a problem for the entire neighborhood because none of them are conforming, the lot sizes. And I think what you're doing is a reasonable solution to basically a state created, the county created problem. That said, it doesn't create, as far as I see, a precedent for allowing people to subdivide these lots further and put new structures on them. This is to correct a one-off situation where you have two existing structures caught up in the changes of zoning regulations since 1963. As far as I'm concerned, yes, I would agree with your request, but put in the stipulation that we're recognizing them as legal, as lawful constructed properties.
Ms. Fordmount?
So I agree that they are lawful structures. That is obvious that they've given you water and sewer in the past. My hesitation is allowing them to be split with the variances into two usable or sellable properties. The hardship, I understand, could potentially be there, but you bought the property, so it wasn't a hardship for the last person to sell that property. The concern I have is that it sets a precedent for the neighborhood, that if there are people who have two lots, that this could potentially add to the density of that neighborhood that has very tight streets. 48th Street, this property has that. Are they lawful structures? Yes, I agree that they're lawful structures. Do I agree with the variances being applied to this so that it can be split into two? I don't, actually. I think it sets a precedent for a neighborhood that's not set up for even more density than it has now. So I'm not sure where that leaves us. The lawfulness of the structures, I agree with. The variances, I don't.
Mr. Olds?
Yeah, that's kind of where I concur with that overall view, and yet also with the testimony given, we're gonna be faced with, I mean, we're thinking of the future for what happens with this beyond this, if this all goes okay, the precedent gets set. If you're sitting on a future board and powers that be, have to consider that with traffic, fire access, police access, all the things that come with all that, and what does that really set into motion? And I'm not sure. I mean, it's something that you have to take into consideration long-term. Yet on the face of it, everything's fine. I mean, you've proven lawful use, everything about that says it's lawful to do that. But setting the precedent of making two separate parcels, I can't say how that wouldn't start being duplicated. I mean, if I was the next door neighbor, that's the first thing I would do. I mean, it makes sense. And that could be beneficial to people, that's fine, but long-term, infrastructure has to be figured out. And there's already an infrastructure problem there. So,
And you can potentially rent both of those the way they are currently, as long as you can get water allocation to the back, right? They don't need to be split to be able to be rented.
and that's kind of how I look at it. And I don't know if we're able to ask further questions.
No.
Right, so I'm thinking, is it to make it more sellable, to be able to sell those lots individually? I would assume.
Yeah.
That's what it would be. I would too,
Can I,
if it was my property.
I think we're getting caught in the weeds here.
I'm
And,
just thinking of the
and what I'm saying is, there are two lots. There's two existing structures that are 80 years old.
Mhm.
They're already there. They did, when they were built, the two lots were purchased by the same people. They added an additional house at some point in time. There's two structures. We didn't add a single dwelling to these two lots. The size of the lots is exactly the same as what it was. What they're requesting is for the lots to be exactly the same size as what they are today. They're just reconfigured to accurately reflect where the dwellings are built. And so, as far as precedent goes, if someone else has two lots side by side with one dwelling, they own both lots with one dwelling, well, then they gotta get a building permit. They've gotta go through the entire process. This is nothing more than reconfiguring the boundary lines on two existing houses on two lots. That's all it is.
I don't think we're creating a precedent because of
Yeah,
that.
No, I didn't say it was creating
It's
one, I'm just saying there's
unique.
potential, but
It's
yeah.
not gonna be a situation where someone else can come in and say, I've got 9,000 square feet, I'm in an R 10,000 area,
Mhm.
I can divide this up. No. What we're trying to do is correct a wrong that's been there for 80 years.
I get it. Mhm.
It was the county that imposed this situation on the owners of the property, creating that hardship. So I don't think it's fair to say that, no, fair's not the right word. I would disagree with your comment, Mr. Rhodes. I would say that we're not creating a precedent. We're not allowing other people to use this as an opportunity to subdivide these lots further. This is to correct a county-imposed problem on the owners of this property.
Right, understood. And I think also in response, any future, as Mr. Bowersox made it clear, as things come up in the future from a density standpoint, it becomes a problem. There's separate cases that are brought before boards and then
Right.
decisions have to be made.
Right.
And that's really the answer.
Okay.
and we need to realize the lot width is only 30 feet. 30 feet. That's a first down. I mean, look at the sidelines. Those two guys on each end of the chain, they ain't that far apart.
Yeah.
I mean, 30 feet, first down. That's
This-
all the width is.
But a line across a map drastically changes the difference of how that property can be used. We're saying it's just a line across, but it's not. Now you can sell two different properties. It
But-
is a difference, but it does set a precedent for the future,
Oh,
because
I
these-
agree-
there-
I
we
agree
don't
with
know
that.
all the other lots. I don't know if there are two dwellings on,
But-
I don't know who owns what.
But they had, if the first dwelling was actually on the left-hand portion only,
Yeah.
because the back lot is on the right-hand portion, they would have the ability to sell them separately anyway.
Right.
So I don't see where that's, I understand where you're coming from, Julie, absolutely. But if that front lot would have been only, 10 yards, as opposed to whatever the width is, that the actual house is,
About 8.
yeah, so, I mean, I just, I don't see it as being an issue, and I don't see it as setting a precedence based on the uniqueness of these two lots when they were formed, when zoning came into place, and also when they were built. New construction, if they were asking to do new construction on the upper lot next to, 48th Street, at this point, that would be totally different, but these lots, these dwellings are, I mean, they predate zoning by a long shot here in Carroll County.
20 years. If you look at the city, the Exhibit 2, every dwelling shown on here is right across the line.
Right, they're all.
Even the garage on Lot 22 crosses into Lot 23. So it's, the whole neighborhood is non-conforming.
Yep.
So,
And it's not like, for example, let's go to lot 22 and 23. If they were to come in and request something be put on 23, to divide 22 and 23 and actually put a dwelling on 23, that's new construction. This is existing construction.
right.
That's the distinguishing factor in my mind. Okay, any more discussion?
I'll give you a,
Wait a minute, any more discussion before we have a motion?
no, I'm,
Okay, very good. I'll entertain a motion.
okay. In case number 6558 before the Board of Zoning Appeals, that the board recognizes that the structures are lawfully constructed residences on lots 20 and 21, and approves the application for a modification of the non-conforming use of 2 lots and variances for the minimum lot width and size of each lot.
Okay, do I have a second on the motion?
I'll second it.
Okay, discussion on the motion.
I'm sticking with my other one. I think it's lawful, but I don't agree with the variances.
My only comment is I understand and I accept the facts as they are. It's probably could be a future problem, but that's going to have to be decided by future boards. So I'm in concurrence to approve.
Okay,
Perhaps, hang on, let me suggest this, that the structures, the existing structures, would that strengthen it as far as you're
Well,
concerned?
it does. No, that's why I'm saying what I'm saying. I accept what we're doing here today and why, and I simply brought up future consideration for, not saying there's necessarily a pattern here. It's just hard to look at this and not think of it. That's all.
Would addressing that it does not create a precedent?
no,
Any value?
I can't say that.
yeah, I would, just let
No,
it go.
I'm comfortable with moving forward here. I just stated some
Okay.
concerns. That's it.
So I've added the word existing. Let me read it again. In the case number 6558 before the Board of Zoning Appeals, that the board recognizes that the existing structures are lawfully constructed residences on lots 20 and 21, and approves the application for a modification of the non-conforming use of 2 lots and variances for the minimum lot width and size of each lot.
Is that acceptable?
That's acceptable.
Okay.
Yep.
So it's
That's
been
what it was.
modified, and so that's the actual motion that's on the floor. Any further discussion? Seeing none, all those in favor, aye.
Aye.
All those opposed, no.
No?
Motion carries. Our oral decision will become final upon a written decision which will be issued within 30 days unless otherwise extended by this board. The board's decision may be appealed by filing a petition for judicial review with the clerk of the circuit court or Carroll County in accordance with the provisions of Chapter 200, Title 7 of the Maryland Rules of Procedure. The appeal must be filed within 30 days of the date of the board's written decision. Thank you very much, and this hearing is adjourned.